Collaborative divorce was introduced in Minnesota about 20 years ago. And 20 years ago, most divorces took a litigation path. And so collaborative law was really interesting to both lawyers and clients because the idea was you would never go to court. And that's still the idea today. If you go into a collaborative law relationship, you have to agree, and your lawyers have to agree, that if you don't settle the case, you have to find other lawyers to go to court and have your trial or do any kind of court involvement motion practice. And that worked 20 years ago. In the past 20 years, divorce litigation has become very rare. Not many cases go to trial because most divorces are done now through an alternative dispute process that is very similar to collaborative law. We use neutrals. So if you have a business, we would get a neutral accountant or CPA to value it. If you have a custody issue, we would look for a neutral psychologist. And then we go to mediation and hammer out the details in mediation. And there's very little motion practice or litigation. But in those few cases that can't be settled in an alternative dispute process, your lawyer that's been representing you for all those months can continue to represent you and take the case to trial if necessary. And that is the big difference between collaborative law and what some people talk about as just a straight divorce process. A lot of people don't like to change lawyers in the middle of their case, and it can be very expensive to do that. And so on balance, most of the time I suggest to people that they try to do what I call a cooperative divorce, where your lawyer can stay on throughout the case, but you're committed to settling.